We're filming today's session because we changed the time for Inventing Profit from evenings to lunch, and there were a lot of people who wanted to make it but couldn't. So anyway, we're going to hopefully videotape the whole thing and put it out on the website so those who couldn't make it can still see what it was all about. Just to pick up on something that Bev said, I've been a chamber member for about 5 years, and some of the programs that I've availed myself of have been Pathways to Success, which is a program for business owners to get together and be able to talk confidentially about problems that face businesses. I've been a member of NetForce, which is a networking group, and I've come to an awful lot of their presentations. A lot of the lunchtime presentations are very good. So anyway, let me give you a little background. Inventing Profit was founded by myself and a fellow named Joe Donnie, who's the president of Learn Solutions, about a year ago. And when Joe and I were talking about the various challenges that our inventors faced, we found that a lot had gotten some really bad information, mainly from invention promotion companies, had been fleeced of $10,000 or $15,000 before they'd made their first prototype. So we decided to just try to form this group as kind of a free resource. And so every time we hold a meeting, there'll be a different speaker. I'm leading off this year, as is the tradition, but we'll have different speakers every time that will be speaking on different aspects of the invention process. So anyway, I know the Chamber is getting the speakers lined up for 2013, so anyway, if you keep checking back, you should be able to find out who the speakers are, and then either attend or not attend, depending on your interest. I know there's also some discussion of having some sort of a Shark Tank competition at the Business Expo this year. We'll have to see if that comes to fruition or not. But anyway, the group is free, advice is free, there are no membership dues, we don't sell your email address to spam companies or anything like that. So we're a very relaxed group, so feel free to come by anytime you'd like to the meetings, and hopefully you'll learn something. So today I'm going to be talking about provisional patents, and I'm a patent attorney. I got out of law school in 1985 and was a general practitioner for a number of years and really hated it. And then I found out that with my science background, I could become a patent attorney. And so I became a patent attorney in 2001 and cut out all the other aspects of my practice within 6 months because patent work was really fun. I got to deal with people. Most people who deal with lawyers, you're dealing with them in a negative sense. Either somebody screwed you over in business, so you've got to sue them, or you got sued by somebody, or you're in trouble with the law, or so your neighbor's in trouble with your law. Anyway, with patents, you're dealing with people at a much more positive phase of their life because they've invented something and they want to try to make some money off of it. So anyway, I feel very fortunate to have gotten that undergraduate science degree before I knew what I'd do with it, and actually became a patent attorney. So our office is right over on the other side of the airport, and I will hang around afterwards and answer any questions that you have, at least until they kick us out of the room. Okay, first of all, we have to start out with the last bit of legalese you'll have to listen to, 35 U.S.C. 102. This is a nasty little law that's been the bane of many inventors. It says you have 1 year from the time you first publicly disclose your invention until you have to have a patent application filed on it. Otherwise, your own public disclosure can be used as what's called prior art against you. It can be used to either shoot down your patent application or later for somebody else to invalidate any resulting patents. So, all of you came here with ideas, don't share them with the group, please. I am an attorney, you have attorney-client privilege with me, but unless we have a whole bunch of other criminal defense attorneys out there who hate their work and you're the only non-attorney in the business, or in the room here, you will be publicly disclosing your invention, so please don't. Okay, a quick bit of background on intellectual property, just so we can put this rather specialized and narrow area of my presentation into context. There are 3 types of intellectual property out there. There's patents, trademarks, and copyrights. These are things you can apply for. There's also something called a trade secret, but you don't apply for that. You either get it or you don't. You either have it or you lose it. So a patent is a way that you can protect an idea. Now, to quote the statute, a patent gives you the right to exclude others from making, using, or selling your invention in the country in which the patent is issued. What does that mean? It means you get a limited monopoly on your idea. So a patent is a way you can protect an idea. And the example here is the iPod, which was, upon its invention, a really unique way of storing, sorting, and regurgitating music to people. So we have patent law because if you couldn't protect your ideas, there'd really be no reason to be an inventor, no reason to have an R&D department. Scientists that'd be more of a hobby than a profession. So patent law allows you to protect your ideas. The second type of intellectual property is a trademark. Now, a trademark is different from a patent in that it protects an identity, mainly, in most cases, a brand identity or a product identity. But basically, trademarks relate to who is selling the product, so that when you buy a Ford car, you know it's made by Ford Detroit instead of Ford Mongolia or Ford Guyana or Ford Brazil. Trademarks help you protect a brand name. So if we didn't have trademark law, you wouldn't know who you're buying your products from. The example here is the Apple symbol. A copyright is the third type of intellectual property that's most commonly used by inventors. Now, in its strictest sense, a copyright protects some sort of artistic creation, and it gives the creator of the art or the holder of the copyright certain rights, the main one of which is the right to affect and control the reproduction of the work. So all those little 13-year-old kids are getting sued by Sony Music Company for downloading songs. That's a copyright violation. Sony's saying we have the copyright on the songs. You took the song that you downloaded and you reproduced it without our permission, and then you either gave it or sold it away to your friends. A lot of inventors shut their ears when they hear the word copyright because they say, okay, copyright doesn't apply to me, it's just for artists. And yes, in its traditional sense, copyright is a way that you can protect things like your owner's manuals and your trade show brochures, as well as your movies and your songs and things like that. But one of the most important things to an inventor is or should become your website. You can protect a website with a copyright. An awful lot of people out there that think that Control-C, Control-V is a fair way to make up a website. And a copyright can be legally protected, or a copyright can be used to legally protect a website. So for those of you who are inventors who have a product that you want to get out there and sell, don't forget that a copyright can protect you. Okay, patents. Patents, again, they protect an idea. There are three basic types of patents out there. There is a utility patent, a provisional patent, and a design patent. Now, a utility patent protects how something works. It protects the function of an item. For most inventors, these are the most expensive, the most frustrating, the most time-consuming, and the most valuable patent you can get. So if you can protect how something works, you've got a really good shot at making more money than if you just protect it with a design patent, which protects how something looks. So design patents and utility patents. With utility patents, they usually take a couple years to be examined. They're usually at least $5,000 to $10,000 to get prepared and filed. Right now they have about a 50% success rate with the U.S. Patent and Trademark Office. We have a better rate than that because we urge our clients to get good prior art searches done before they file the patent application, but that's another topic altogether. Once you get a utility patent, if you're lucky enough to get one, they're good for 20 years from the date of filing, and since I've already told you it's going to take a couple years to get examined, most utility patent holders end up with approximately 17 to 18 years of useful life of their patent. And a lot of inventors freak out. They say, well, there's no way I'm going to give away my invention for just 18 years of protection. Well, don't worry about it. As an inventor, unless you happen to have invented the laptop computer or the hula hoop or the light bulb, you're going to make all your money in the first 5 years. And if you're not making money by the end of the first 5 years, you're probably not going to make money. So don't focus on how long it's good for. Focus on how you're going to make money right when you get the patent pending status. Design patents, on the other hand, have a great success rate. Over 95% of our applicants get them. They cost usually $2,000 start to finish. They're examined within 10 months. They're good for 14 years from the date of issue, but again, don't worry about that. Worry about how you're going to make money the first 5 years. And so the design patent seems like a really good deal until you realize it just protects the shape of an item, not the function. And as a result, it's much easier to design around a design patent to get around your patent than it is if you get a utility patent on the function. For example, that coffee cup there, if you had a utility patent on a cylindrical device with a bottom that held coffee, any one of the cups here on the table would infringe your patent. But if you had a design patent just on that shape of a coffee cup, well, certainly her Starbucks is going to avoid that because it's much bigger and has, a straw hanging out of it. So for most people, utility patents are better, but they cost more money and they're more frustrating. A lot of people, when they first start out as inventors, they say, well, I don't really want to sink all this money into a patent application. I want to test the market first. And the safest and easiest and cheapest way to test the market is with the topic of today's conversation, which is the provisional. Now, a provisional patent application is basically you're buying yourself a 1-year grace period. And they are inexpensive compared to utility patents, usually $3,000 to $5,000 for provisional patent applications. They last for a year, and so during that year, boy, you'd better be on your stick, because if you just sit around and waste that year, you will have wasted all of your money. Hi, come in, have a seat wherever you find a seat. Don't worry about it. And so they last for only a year, and at the end of that year, you have to either file a utility patent application, that's the big dog up here, that refers back, relates back, grabs a priority date from the provisional application, or you lose your priority date. So the provisional, it's a great placeholder for a year. If it was this easy, again, I'd be an inventor, I wouldn't be a patent attorney, because it would be easy money, and it's not. There are a lot of pitfalls along the way, and I'm only going to be able to talk about one of them today, which is the problems that you can have with provisional patent applications. I just did yesterday a YouTube video on some of the scams that await trademark applicants, and actually I read some of the offers coming in from some of the foreign companies on this, and I don't know, Dina Dennis does all of our video work. I don't know if she's going to be able to cut out all the times that I basically lost it because I was laughing at the poor English that they were using in this, but there are a lot of scams out there, and I'm just going to go over how you use provisionals, but suffice to say, you should educate yourself as much as possible. So, this is the typical provisional patent timeline. Oh, and by the way, if you'd like a copy of this PowerPoint presentation, you can just email Dina Dennis, Dina@iciplaw.com, and she can send it out to you along with the class handout if you'd like an extra copy to mark up or turn into paper airplanes or something like that. So, theoretically, you should start with something called a prior art search before you file for provisional patent protection. Now, a prior art search is a search that you can make yourself, or you can pay somebody to do for you, where you look for all the issued patents and published patent applications and things for sale on eBay that may be relevant to whether or not you can get a patent on your idea. Now, we've got a good YouTube video on how to do your own. You can just, if you just Google, get on YouTube, Google, put in my last name in prior art searches, you'll find it. And in there, I tell you how to do your own. And it's fairly simple, so do your own. Then, if you still think there's hope at the end of that, my advice is pay a professional company like National Patent Services or Legal Advantage. They'll charge you $400 to $700 for a prior art search, but the prior art search cost is always dwarfed by the cost of the patent application. So it's much better to send a few hundred to see whether you want to spend a few thousand on a patent application. So you should get the prior art search done first. Then you file a provisional. Now, the minute you file the provisional patent application, you become patent pending. And you basically have stuck a stick in the ground on that date, and the stick is on file with the U.S. Patent and Trademark Office, and the stick says, as of this date, I'm the inventor that's claiming rights to this. Now, if you play your cards properly, you can keep those rights. If you play your cards improperly, you'll lose those rights, and that's basically what we're talking about today. So after you have filed the provisional, if you haven't done the prior art search before, you most certainly should do it afterwards. Then again, spend that next year doing everything possible to see whether or not your invention is worth pursuing. And again, with you being patent pending, you've got what's called a priority date on your patent application, though. So even if somebody steals your idea, files their own patent application, so long as your provisional application was written well, you have priority over them. You've won the race to the patent office. And then hopefully at least give us 2 months to work on the utility patent application. I have turned a provisional into a utility in 1 day. It was the worst patent application I've ever written in my life. We really like at least a few weeks to do a good job on this, get a lot of feedback, get the drawings done perfectly. So ideally, 10 months into the process, you've decided whether or not you want to go forward with the utility patent application. All right, so here's the timeline of somebody who's doing it right. So you filed the provisional January 1st, 2013. Then you disclose. Now, a public disclosure, that little law 35 U.S.C. 103 I talked about when everybody came in here, that law is triggered by any public disclosure, including a public disclosure that you make. So what is a public disclosure? Well, selling it on eBay, walking around a trade show with a trade show booth and say, hey, anybody want to license my cup? Having a magazine article or a newspaper article written about you as an inventor. These are all public disclosures. So the safest way to do this is provisional first, then public disclosure. And then last but not least, file the utility patent application within a year of the provisional filing date. Now, if the provisional provides adequate support, that is, the provisional is well enough written so the USPTO examiner, when he or she sees the utility patent application, they will look back at your provisional. And if your provisional details the invention well enough so that the USPTO examiner says, yeah, I agree, the inventor had this invention in mind when the provisional was filed, what they will do is they will give you a priority date for your utility of the provisional. So your utility would actually have a priority date of January 1st, 2013. That's why if you do this properly, you're safe, because if somebody steals your idea and files their own patent application after the disclosure, well, you've got the priority date. So theoretically, this is how it works perfectly. All right. The key points here: provisional filed before disclosure. Provisional's got to be well written so it later on can be found to support the utility patent application. Then you got to file a utility patent application within a year of the provisional filing date. So those are the three key steps with proper use of provisionals. Okay, now we're going to go over the problems. And this is the good, the bad, and the risky. The good is if you do it right. The bad is if you do it wrong. The risky is if you take chances you don't need to take. So here's the first Achilles heel of provisionals. This is the cheap inventor. This is somebody who didn't want to do the prior art search, didn't want to file the provisional patent application, and they decided to test the market. So in 2007, they took their invention to a trade show, and they set up a booth, and nobody was really that interested who walked by. They were all bummed out. They said, okay, forget it, I'm giving up on this. So about 6 years later, somebody calls them on the phone and says, hey, I remember you from that trade show. Whatever happened with your invention? And they say, well, it's still my invention. And they say, well, I might be interested to license that. What's the patent pending status on that? And the inventor says, what? I can't hear you. What? Call me back tomorrow. My phone isn't working. They hang it up. They quickly file a provisional patent. Then the next day they talk to the prospective licensee and they say, well, yes, I am patent pending. As a matter of fact, I would have told you yesterday, but the phone cut out. Okay, so they filed the provisional January 1st, 2013. And then this potential licensee is really stoked on this idea, and they say, well, yeah, I'll give you a $20,000 advance royalty. Here, take the money, but you've got a good patent on this, don't you? Oh yeah, I got a fine patent. So they filed the utility December 31st, 2013. So they've done everything right, and they've had to pay the patent attorney for this, and they had to pay the patent attorney for this. And let's say the utility patent ends up getting granted. Well, this sounds fine, except that anybody who has that trade show calendar or can get on archives.org or happens to have the newspaper article that was written about the inventor based on the trade show way back in 2007, they can invalidate the patent. And so the main problem here is they've done everything right except that they waited too long. And the problem is that they didn't get told at the provisional date, oh, you're going to have an invalid patent, so don't pay the money. They paid all the money all the way through. They can have a patent, and then somebody comes up to them with a copy of that trade show, the 2007 trade show synopsis. And there's a picture of them with their invention and their arm around the trade show director posing for a picture. And they say, you will give me a free license, won't you? And the inventor says, I would love to give you a free license. That's all you can say, because otherwise the person with that 2007 trade show brochure can destroy their patent. So Achilles heel number one, you can't wait more than a year. And this happens way, way, way more times than I care to remember. So the problem again here is you paid for everything, you got a patent, but it was fatally flawed and you didn't know it at the time. Anybody with proof of that 2007 trade show can then invalidate your patent later on. So that's Achilles heel number one, you wait too long. Achilles heel number two, well, this is kind of a version of the cheap inventor. They disclosed first, and then they filed a provisional. And let's say they did the provisional on El Cheapo and Quico provisionalpatents.com. So they filed the provisional within a year of the disclosure, so they've avoided 35 U.S.C. 102. And then they file a utility patent application. And so they think, well, this is okay. The utility will reach back and grab this filing date, which is less than a year after my disclosure. I'm okay. The problem is that when you base a utility patent application on a provisional application, the minute that gets to the USPTO, as soon as it's examined, the first thing the examiner does is they look at the provisional and they say, does the provisional support the utility? And if it doesn't support the utility patent application, they're going to give you the utility patent application as your filing date, not the provisional. And so in this case, this guy ends up with the effective filing date of 12/31/2013, which is unfortunately more than a year after public disclosure. So anyway, you can shoot yourself that way pretty easily as well. You can shoot yourself that way pretty well as well. Okay, there we go. So again, the problem here is that you can pay for everything and you've got a fatally flawed patent. Now, if the examiner doesn't find out about the public disclosure, the examiner can still give you the patent, and then you're going to have to pay the patent attorney to get the patent, but the patent can then be taken away from you. Also, the USPTO examiner, they're getting very good at looking at archives.org or the other internet searching sites. So they'll go back through the exhibitor lists and they'll see if there's a record of you having disclosed your invention more than a year before. And they have been known to actually catch that.